Imagine spending a lifetime building a comfortable life together with your spouse, saving diligently, and creating a home. Now, facing the potential need for long-term care for one partner, a common worry arises. Will all those shared assets be lost to cover care costs, leaving the other spouse in financial hardship? The good news is that for married couples, Medicaid does offer specific protections designed to prevent the community spouse, the one not needing long-term care, from becoming impoverished. These vital safeguards ensure that you do not have to spend down every last cent of your shared savings before one spouse can qualify for assistance with nursing home or long-term care expenses. These protections are often called spousal impoverishment rules, and they are rooted in federal law. There are two main components you will want to understand. First is the Community Spouse Resource Allowance, or CSRA. This is the amount of shared assets the community spouse is allowed to keep, free from Medicaid spend-down requirements. It is a specific dollar amount, and it is usually adjusted each year. Without this allowance, the healthy spouse could be forced to deplete almost all their resources, leaving them with nothing. Second is the Minimum Monthly Maintenance Needs Allowance, or MMMNA. This protects a portion of the institutionalized spouse's income for the community spouse if their own income falls below a certain threshold. It ensures the community spouse has enough income to meet their basic living expenses. The way these allowances are calculated involves looking at the couple's combined countable assets at the time the institutionalized spouse enters a medical institution or applies for Medicaid. States typically set limits for the CSRA within a federally defined range, often either a flat amount or 50% of the couple's total countable assets, up to a maximum. It is important to know that assets are categorized as either countable, which means they are considered when determining eligibility, or non-countable, which are protected. For example, the family home, one vehicle, and personal belongings are usually considered non-countable assets under specific conditions. Understanding these distinctions is crucial for proper planning and application. So, what can you do with this information? The most practical first step is to gather all your financial documents. Understand what your combined countable assets are and what your income streams look like. Next, familiarize yourself with your state's specific CSRA and MMMNA limits, as these can vary. While the protections exist, navigating the application process and understanding what assets are considered countable versus non-countable can be complex. Consulting with an elder law attorney early in the process is highly recommended to properly assess your unique situation and options. A little-known fact is that beyond the asset allowances, there is also the concept of a resource assessment. This assessment is often completed when a spouse first enters long-term care, providing an official snapshot of a couple's assets that can be vital for future Medicaid applications. It is not an application itself, but a crucial step in understanding your financial landscape. Another key point is that income and asset rules are treated differently. The income of the community spouse is generally not counted when determining the institutionalized spouse's eligibility, although a portion of the institutionalized spouse's income might be allocated to the community spouse through the MMMNA. Ultimately, the goal of these Medicaid spousal protections is to strike a balance, to provide assistance for long-term care while safeguarding the financial well-being of the healthy spouse. By understanding these key rules and planning proactively, married couples can navigate the complexities of long-term care financing with greater confidence, ensuring both partners are cared for and their shared legacy is preserved.